He always sits there. I always sit at 23, usually. So anyway, I appreciate everybody coming out. This is the full committee meeting of Juvenile Justice. There are 2 agenda items that we will be dealing with. The first one that we're going to hear is HB 5. There is a substitute that should be available to all the committee members. It is LC 297435S. And we will, and there was not necessarily so much the official fiscal note, but there was notes regarding the financial impact to the state that was provided to committee members. So everybody can refer to that whenever they're considering the fiscal impact of HB 5. So I will ask the bill's author, Chairman Caldwell, to come forward. Okay, all right. I believe there are some folks from the Council of Juvenile Court Judges that are going to be coming as well.
Thank you, Madam Chair.
Okay.
And members of the committee, before you last week on House Bill 5 at that time when we presented it just at that time for discussion. Since that time, based on information that, of course, we received from your committee, as well as discussions, of course, with your chairperson, and in trying to get a bill that is first needed, as well as a bill that makes sense and one that can save the money, money for the state. We have reworked, and as the chair lady said, you're looking at LC 297435S. And what this bill does, as I explained last week, it pays a salary to the existing juvenile court judges who exist. Under present law, they're paid a grant to each circuit. They're paid by a grant. This would change it from a grant to a direct pay to those individuals who was in office January 1 of 2017. And that's very important so that if a county or judicial circuit increased their judges after the effective date of this bill, if it passes, they would not get state funds. They'd have to get funds from their county, not from the state. And so we were trying to craft this, and that's the reason if you'll look on lines 12 of this substitute, it says, provided, however, that the number of state court, juvenile court judges in this state shall not exceed the number of such judges which existed on the effective date of this subsection. So what we're trying to do is to limit it so that they couldn't add more and for us to pay more. We also reduced the figures as to what the direct pay would be. And if you will look on your sheet, you will find that we initially had for the judge, the chief judge or the juvenile judge to get $110,000. We reduced that to 10. For those who were working 1 day a week, that had been, that is now 20. Those for the part-times is 40 and 60 and 80. So what we have done is try to rework this to make it appealable and something that is needed, and certainly I stand for any questions that anybody might have, and have people from the juvenile court judges that are probably more expert in this than I am.
Okay, thank you, Chairman Caldwell. Members of the committee, any questions?
And I understand that it's certainly having to do with funding, and if it's not funded, it doesn't pay.
Representative Quick.
Thank you, Madam Chair. And Chairman Caldwell, thank you for your presentation. I have a question just generally about uniformity throughout the state. We're having a discussion of sorts about local supplements in the Superior Court context, and I'm just curious, first and foremost, is there some uniformity about how circuits decide whether or not they need additional judges and from a case count perspective? And then a secondary question to that is, how are you counting cases for caseload purposes in juvenile court?
Representative Quick, I'm going to let somebody else answer particularly the second part of that question.
You're going to phone a friend.
The first part of it is basically by the judges of the superior courts in the circuits. based on when the people come to them, the county commissioners or whomever, the clerks of the court, and say, we need additional help in the juvenile court system. And that's basically done by the Superior Court judges. But I'm gonna let the experts, if you don't mind, give you the answers to that, okay?
Thank you, sir.
And I concur with Representative Caldwell with regard to the salary is set by the Superior Court judges per the statute. So that's a local funding issue there from that standpoint. With regard to the case counts, and there is a uniform docketing system. It is always a challenge to make sure that you are counting apples and apples, and that everybody's docketing in clerk's office is working those cases the same way from the standpoint of case counts. But there is a uniform docketing system, and obviously in the future that will be an issue that we'll have to take up with regard to the second part of this process. And you know, as the representative indicated, that there would be a record date on the funding. How many juvenile court judges are they? We know that that's not going to be a static number forever. There will have to be new juvenile court judgeship positions created, and that will be driven by that case count docketing system. Did that answer your question?
Yes, sir, in part. May I follow up just with one, Madam Chair? And so from a standpoint of, in the juvenile court context, the uniform docketing system, you're actually docketing more than just a case per se. You're docketing the different motions. You're talking about there's a system where the different motions and petitions are docketed, or it is a docketing system that is case specific?
There's more detail to it than just a case, because it doesn't compare to the Superior Court docketing system from the standpoint that in juvenile court you may have a dependency case. That case would have at least 5 hearings within the first 12 months. Now, if there are situations where then the department then files a termination of parental rights case that's based on that dependency, I mean, that is a new filing. And so, yes, it is driven sometimes by the new filings in a case.
And is there separate record keeping for the number of hearings that are actually held, that is full-blown evidentiary hearings, as opposed to where the parties come in and consent to relief?
I'm not sure everybody would have the detail to distinguish. We had a 4-hour hearing, or the parties were able to settle their case by some agreement and stipulation. I'm not sure everybody would have the ability to distinguish between this case took 4 hours just by looking at the data, and this other case may have only taken 30 minutes because of the announcement or stipulation. It's driven a little bit by the case management system that each court uses. They're not all the same because all the counties are different, and all the counties have different resources available to them on what they can do and what they have available. There's one that the council, I don't want to say sponsors or encourages, but there's one that we've been working with for a number of years called JCATS, that's specifically set up for juvenile court case management, and it has those types of categories and criteria that are unique to juvenile court. But as far as capturing the actual time, I'm not sure that the systems would actually capture the time. This one termination case may take a week. Another termination of parental rights case may only take, 4 hours. It's going to be hard to capture the amount of time, but the system will have to come up with a formula to weight those averages through some type of, time and work study. I'm certain of it.
But right now, there's no uniformity across the circuits in terms of case management software or record keeping.
I believe that would be correct, that there's not a uniformity among the case management systems. I think there's probably more uniformity with regard to counting cases from the standpoint of following the uniform guidelines, the docketing guidelines.
Thank you, sir.
Thank you. Representative Efstration.
Thank you, Madam Chair. Thank you, Chairman Caldwell. I had a conflict at the previous meeting, so forgive me if I'm getting caught up here. But as I understood it, the purpose of the legislation is a long-term cost savings for the state.
I would say yes, long-term, and to bring some uniformity and correct some disparity at the present time, based on the number of judges that are now serving, and that it was just a grant that was being paid. So those individuals are suffering. And if we can do it to a per judge instead of per circuit, it would help these that are receiving nothing, and it would bring some of them up to a parity level for the time that they have to spend, particularly if they're full-time. So
Okay.
that's basic. And initially, it was $3.4 million that we were looking at, and with this figure, it's 2.7 million. So we've reduced it from the original. But trying to answer your question.
So I certainly understand the need for consistency, but as part of that is really the cause of the cost savings that the state would not bear the expense of additional judges in the
Yes,
future.
and that's the reason they put the provision in the first section that I talked about. Yes.
Well, I guess just to kind of get to it, my only concern would be an obstacle to the creation for new judges in the future due to population increases, the need for judges to work there. If you could just speak to that.
I don't, Representative Administration, I don't see that as happening because it's done now. If a county needs one, the county commissioners and Superior Court judges get together and determine what they need anyway. But I'm not disputing what you say. I don't necessarily see that as being an obstacle to it, no.
Thank you.
Thank you, Representative Administration. Chairman Welch.
Thank you, Madam Chair. To Chairman Caldwell, is it not true that the Appropriations Subcommittee on Public Safety has appropriated an amount of money that is about $2 million less than this amount? It's an increase, and it's an increase based upon a $15,000 increase on a per circuit basis. Is it not further true that that is that your proposal would be a $2 million increase over that appropriations that's been approved by the Public Safety Subcommittee?
You're absolutely correct, Chairman, 100%.
And is it not further true that that I've provided you with a copy and the chairwoman as well as, and I think that indirectly that has been provided to the Council for Juvenile Judges, a substitute to the bill that you originally proposed as well as the substitute to the one that you're proposing today?
Yes.
That would coincide with the budget
Mr. Chairman,
appropriation.
I do apologize. I don't think that that's really, at this point, we need to discuss the sub. You will have the opportunity to present the sub, but we will have to wait until there is a motion upon what Chairman Caldwell is presenting.
Is it not further true, though, that the shift we're making that you're proposing with your legislation it would essentially be a per judgeship grant, and in that you're shifting the policy of the state to move towards a dedicated sum of money, essentially a salary to juvenile judges from the state?
Absolutely, and I think they deserve it and need it. We're putting more and more on them every day.
And is it not further true that
Last question, Chairman Welch.
Thank you, Madam Chair. Is it not further true that that ultimately this bill would be inconsistent with the appropriations that the Appropriations Committee just approved this morning?
As we sit here right now, yes, but we know it hadn't gone to the Senate yet and don't know what Senate's going to send back. And this bill says if it's not funded, it doesn't happen. That's all I can say. Thank you.
Thank you, Chairman Welch. Representative Collins.
Yes. Chairman, I just had one question for you there. Is it not true that we continue to put more caseloads and there's more cases in juvenile court each and every year?
Absolutely, Representative, and I can say from my personal experience, I never served in the juvenile court as a judge. Don't misunderstand me. But the two in my one circuit are handling right at 3,700 cases between the two of them as we sit here today, and it's almost unbearable for them. Now, I'm not trying to get more judges in there, but at least give those individuals an incentive to stay there because they're good folks, because they are totally overworked. And I'm sure it's pretty much the same way in all the juvenile courts, and everything they deal with on a daily basis is tragedy, as opposed to sometime in Superior Court.
Follow-up question, Representative
I
Collins?
just want to say, thank you for bringing this
Thank you.
to the forefront.
Thank you,
I represent a portion of the Coweta Judicial Circuit, which is Coweta, Heard, Carroll, is it Meriwether? Meriwether. And there's
Troup.
one, Troup County, there's one more there. And that is a huge, huge circuit, and this is desperately needed over there in my part of the world.
Thank you, Representative Collins. Who's 25? Representative Spencer.
At the appropriate time, Madam Chair, I'd like to make a motion.
Okay, hold that. There's a couple more questions that we need to deal with. Representative Evans.
Thank you, Madam Chair. Just a point of clarification, I'm sorry I was late. I think, maybe looking at the wrong bill than the one that,
We are dealing with LC 297435S.
okay, and so the other sub is one that may be moved at some time.
Once there's some motion that's from Representative Caldwell.
Thank you.
Okay, thank you. Who is 10? Representative Oliver and the best seatmate ever.
Thank you. I'm also late, so Representative Evans' question was my question. What bill are we talking about?
We are talking about HB 5. It's LC 297435S.
And as I came in, there was a set of questions about work study, basically. And if I'm remembering correctly, I was not in the General Assembly when the bill was passed in 2000. It was part of my gap years. The determination of how many judges went to each circuit was made at that time based on how many judges were sitting in the offices. And since that time, the determination of going to more judges, I thought, was based on some formula, but has it been totally a local decision
Yes.
historically?
A local decision.
And so the county commission and the juvenile court judges locally make a decision about how much more to go.
Right.
And how many circuits, fast-growing circuits, or how many circuits have increased the number of full-time judges since 2000?
There have been 6 new juvenile court judges created based on county recommendations.
Full-time.
Full-time, and 1 state-funded, that's Atlanta.
And the
Atlanta circuit.
final question, Madam Chair. I think for me and Representative Evans and Holcomb and this isn't going to, maybe Clark County too, I don't think that this bill is going to impact my county. It's going to give my county money, so they're going to be able to put money in their pocket, but my judges are already very, very high, and they're not going to be, my county commissions are not going to, I'm guessing, because I don't control them, are going to move the juvenile court judges up above the Superior Court judges or above the state court judges, because we're all on a train. So it really comes down to how many circuits does this really impact, which may give you an opportunity to explain a piece of paper that's before me that I don't understand, which is this one. Have we talked
Okay.
about this piece of paper?
Yes. Well, we have not specifically discussed that. That was some background information that was provided from the Council of Juvenile Court Judges, just to answer some of the questions that various members of the committee had brought before. I think really to speak to your question about how does it benefit specifically your county, I think really as far as a state, it's more about parity. Because a lot of these juvenile court judges just serve in in areas where less affluence. So I don't know, and how it's appropriated within the individual county. Obviously, that's just a grant to support our juvenile court judges. I think, perhaps our juvenile court judge could speak about some of the increase that they've had in caseload and in demands on juvenile court judges that have occurred, say in the last 5-10 years. Would you like to speak to that for just briefly?
And have you done a work study analysis on that?
On the caseload,
For all the circuits?
I'm not sure I fully understand your question. Let me respond in this way. For example, in the dependency, the DFAC side, in 2013, there were approximately 7,600 children in foster care in 2013. 2016 numbers, the children in foster care went up to 13,000. That was a direct result, well, as the new juvenile code that became effective on January 1, 2014, the additional demands that were placed on the court, the additional requirements that we had, and the department's policies, resulted in an increase in children in foster care. As I mentioned, each one of those cases has at least 5 hearings within the first 7 months. And so that's a 75% increase just in those cases. Now, on the delinquency side, the caseload numbers, fluctuate. I don't think the new code had a direct impact on those caseload numbers, but the challenges that were there on the delinquency side were driven by the new juvenile code also, with regard to finding alternatives to incarceration, creating these community resources, a whole new category, children in need of services, CHINs, that had to be developed and protocols established, and the community support gathered behind that. And the code expects that judges, convene these groups and provide the leadership for these community groups. So, case numbers definitely have gone up across the state, and those are statewide numbers with regard to the dependency side.
Okay.
And I'm not sure that got to your question, Representative Oliver.
It didn't, and I'm going to, if I may.
Okay, sure.
The new code didn't cause more cases to come to the courthouse. It caused more hearings after they came.
Yes, I don't think that the code changed.
The number of
Correct.
child abuse.
Right.
Okay, it didn't cause your workload.
There-
In terms of number of children that came to the courthouse, it changed in terms of number of hearings.
I would agree with you on that.
So I think we can both agree that there have been an increase in the number of children placed into foster care and also the number of required hearings.
Yes.
So there has been a net increase on that. Did you get all your questions answered, Representative Oliver?
We don't have a uniform work study analysis of the secrets of juvenile court. Is that fair to say?
I think that's fair to say, yes.
Okay.
We don't have a work study analysis.
Okay. All right. Any other questions from the committee? Representative Spencer.
Madam Chair, I'd like to make a motion to do pass.
There is a motion to pass. I presume you're talking about LC 29743.
7407S, the substitute that we're talking about.
Okay, we are talking about LC 2974335S. Is the substitute that's under consideration right now.
That one.
So there is a move from Representative Spencer for a motion to pass on LC 2974335S.
Sorry, Judge.
There is a second from Representative Collins. I will thank you, Representative Collins. I'm going to confer with Legislative Counsel. There is a substitute offered by Chairman Welch, so I will recognize him to speak to that sub.
Thank you, Madam Chair. So I would move then to amend the motion and to substitute for the sub L. So the motion would be to amend the proposed substitute with the LC number 29. LC 297407S for the proposed sub before the committee.
Okay, there's a motion. Motion fails without a second. So there is a motion and a second. Is there a second? Okay, Representative Oliver.
Is the difference between Mr. Welch's motion for 7407 and the motion for Mr. Spencer for 7435, that Mr. Welch is for a grant per circuit and Mr. Spencer's is for a grant per judge? Am
That
I
is correct,
about that?
essentially.
And the juvenile court judges are seeking the grant per judge, obviously.
Exactly.
Okay, I'm caught up now.
Okay.
Thank you.
Excellent,
Thank
awesome. As long, you'll have to give me cookies tomorrow. But, okay, there is a motion and a second. So there is a motion and a second to amend is there any discussion? Does anybody have any questions about that? I think Representative Oliver kind of succinctly presented that. Briefly, Representative Welch, we might possibly lose quorum at 2, and Representative Beskin has a bill to present, so we're trying to be brief here on time. So I will allow Chairman Welch to speak briefly, and then I will recognize Representative Quick.
Thank you, and thank you for the second. So the policy question here is one of whether or not we're shifting towards a employment status. This is a grant. The grant question is whether it goes per circuit or per judge. By leaving it as a grant per circuit, it does allow the state to control appropriations for juvenile judges, whether they expand or they do not. The bill as proposed, Caldwell's bill, does not limit or deter the local governments from adding or retracting on the juvenile judges, nor does the proposed substitute that I have before you. But there is a policy question, is whether or not we're going to move in the direction of essentially paying a judge on a per judge basis as opposed to grants to the circuits to allow those circuits to make their decisions at a local level, local decision making based upon what state funding is there. And it is my request to the committee, and it's my position in terms of policy for financing with the state budget, that we move in an incremental basis and that we hold off on a per judgeship allocation for grants and just keep it at a circuit level. Mind you, both bills increase the total funding for those, just at different levels.
Okay. Thank you. Representative Quick, briefly.
Thank you, Madam Chair, and I just want to echo that in terms of why I seconded the motion. What I'm hearing is we've got a situation now where we're trying to freeze what we have in time in terms of counting but that's not been uniform, nor has it been studied. And so I think Chairman Welch's approach, as he says, incrementally provides the assistance in fairness to the circuit so that they can each devise their own plan with a uniform level of state funding until we can get a handle on what the workload actually is per circuit.
Okay. Thank you. Representative Oliver.
Both provisions before the committee increase the salaries for what I would consider the less populated circuits where there's probably only one judge, and is going to enhance the folks that probably need it most. I think both do that. I'm going to support Representative Caldwell's motion, though, because for those large counties that have absorbed so much of the cost of expanded work and for juvenile court judges, I think it's a more fair distribution, if that's helpful in my analysis for the committee.
Okay. All right. So there is a motion and a second. All those in favor signify by Representative Evans. Oh, hold on. Oh, there you go.
I just want to clarify that for those of us who wish to vote for the bill that's supported by the juvenile court judges, we should vote no on the motion that you're about to call.
That is correct. So all those in favor, please signify by raising your hand. 1, 2, 3. Okay. All those opposed? Okay. Motion fails. So we have before us the original question. There is a motion and a second on due pass LC 297435S. There was a motion and a second. All those in favor, please signify by raising your hands if you're in favor. All those opposed? Motion carries.
Thank you very much, Madam.
Thank you, Chairman Caldwell. Thank you. The next item of business is going to be HB 305. It's going to be presented by Representative Beskin. Okay. I'm sorry. I have a hard time following it. I know. See, mine says... Let me round that up. All right. Where's that? Where's that? Okay. All right. Representative Beskin. Representative Beskin is here to present We do not have the HB number, so I do apologize. It is HB 305, but the LC number is LC 410980. That is the matter that's before us, and I will recognize Representative Baskin to speak to the bill.
Thank you, Madam Chair and members of the committee. Today I bring you this bill, which would add step-parents and former step-parents to a list of third parties that a court, in its discretion, could award the custody of a child to. Currently, they are not a party to whom the court has discretion to award custody of a child, and this would come, it would come as a revision to OCGA 19-7-1. And do y'all have copies of the statute? You don't have copies of the whole statute in your folders, but OCGA 19-7-1 is the section entitled "In Whom Parental Power Lies, How Such Power is Lost," and for recovery for homicide of child, which obviously we're not talking about here. But this particular section we're talking about is paren B1. And this comes up, actually I'm focused on this particular issue because of a case. Did everybody get a copy of the Phillips v. Phillips case in your file?
I believe that members of the committee, and please raise your hand, indicate if you did not get a copy of that case.
I didn't realize this committee was quite
we did not
so
have
large.
enough
We had
copies for everybody,
15
so if
copies.
anybody needs an extra, then,
Okay.
okay. So, thank you, please proceed.
Okay, before I tell you about this particular case, let me say that this statute provides and requires that before a judge awards the custody of a child to a non-related third party, meaning someone who is not the parent of that child, that the court determine that the parent is unfit. The parental power would have to have been lost to this child. And the court has to exercise its discretion in this regard. If it's going to award the custody to a third party, it's never a matter of law that a child is awarded to a non-related third party, or to a third party, shall I say. This statute provides there is a rebuttable presumption that custody will be awarded to the parent or parents, but the presumption may be overcome by showing that an award of custody to such third party is in the best interest of the child or children. So before a judge ever awards a party custody of a child to a non-parent, the judge has to determine the best interest of the child. In Phillips v. Phillips, which was a case in Cobb County, and it was decided by a colleague of mine in my Inn of Court, Judge Robert Flournoy, the case arose in 2011 with the divorce of a child's mom and stepfather. The stepfather had not adopted this child. In the opinion, it's kind of confusing because there were two children. The parties together had a child, KP, but the issue was about KB. KB was a child that had been brought into the marriage by the mother. And then in 2011, the parties were going through a divorce. There were 3 hearings in this process, 4 actually. There was a hearing on March 22nd of 2011, a temporary hearing. And at that first hearing, Judge Flournoy did enter in order that the father would get joint legal custody and visitation with this child, KB, the one that ultimately resulted in this decision that was, well, I don't want to tell you the end of the story yet. But so in the very first award, the judge acknowledged that this stepfather was a very capable parent and an influential person in this child's life. So that was March. April 25th, well, no, that's not a hearing. In May, there was another hearing, and at this point, the biological mom's mother got involved and testified in this case, and she testified that DFACS had become involved in the situation because KB, the child we're talking about, was under a lot of duress and distress whenever he was in his mother's presence. That's the bio mom's own mother testifying that there's a problem with the mother of this child. In June, there was another hearing, and the court entered a second temporary order continuing the stepfather's custody and visitation rights with KB. At another hearing on June 17th, there was a guardian ad litem. The guardian ad litem testified it was in the child's best interest for Mr. Phillips, the stepfather, to have primary custody, and that KB was, quote, terrified to return home to his mother while she's living with white, that was her boyfriend. The guardian ad litem also testified that the Fulton County DFACS had an open case about this. So then the trial court, Judge Flournoy, entered a third temporary order awarding sole legal and physical custody of KP and KB, that's both children now, their biological child and then the child to whom he's a legal stranger, his stepchild, to Mr. Phillips. The mother was not a good mother, but she had a good lawyer. And that lawyer appealed this and pointed out, it was incorrectly appealed at first to the Supreme Court, but then it ended up in the Court of Appeals, and pointed out that the trial court had no statutory authority to do what it had done, and the appellate court agreed with that and overturned Judge Flournoy's awarding custody of this child to the stepfather. And a couple of quotes here that are relevant. The court said this: the former stepfather is not given the same status as a grandparent, great-grandparent, aunt, uncle, great-aunt, great-uncle, sibling, or adoptive parent under this statute. Those are all the third parties which is the statute currently contemplates. And the court is left with no discretion to determine which placement would be in the child's best interest. In other words, Judge Flournoy didn't have the authority to make this decision to award the child that would be in his best interest to go to the stepfather. Says, our law provides no clear process for resolving this issue, leaving some courts and parties straining to fit the new reality into the old legal structure. The deficiency results in tragedy for some and uncertainty for all. Only the legislature can fix this problem by addressing how a non-biological father may seek custody or at least visitation of a child he has raised and to whom he is bonded. So I bring this bill today to simply give judges discretion to do what so often is in the best interest of a child, to award custody to a step-parent or a former step-parent. Oftentimes, this is the person that is the most capable parent-type figure in this child's life. And I know some of you might wonder, well, is there a distinction between a step-parent and a former step-parent? I would point out that as soon as a divorce happens, that step-parent is a former step-parent. And often change of custody issues come up after the divorce is finalized. So in this kind of case, I texted my friend who was one of the lawyers here, and I don't think he's texted me back yet, to say, when did the divorce here happen? Because it doesn't tell us in this opinion where along here it happened. This particular stepfather may have still been a stepfather and not a former stepfather at the time these orders were entered. But just because a divorce has happened would not have made this mother any better of a parent. And it would have not made the relationship between KB and his stepfather any less of a relationship, other than obviously as time goes on, there will come a point in time when the divorce is so far in the past, maybe a step-parent who did have a very vital relationship with the child would no longer have that. But then you would get back to the discretion of the court. The court is never going to award custody to a stranger or to any of these third parties if there is a parent that is a capable parent, that is a fit parent. So that is good, and I'll be happy to answer any questions.
Okay. Thank you, Representative Buskin. You do have a couple of questions. Representative Efstration.
Thank you, Madam Chair, and thank you, Representative, for bringing this bill. I appreciate your work and our previous discussions on this issue. Would you agree that the ultimate objective here is to provide to allow for discretion in the courtroom so that the statutory framework is not an obstacle to doing what's in the child's best interest?
Absolutely. It's all about the best interest of the child. Thank you.
And would you agree or maybe concede that there might be individuals who would where a custody placement would be in the best interest of the child, but because of a lack of a family relationship, they're not included on this list?
I would agree with that, and I think here in the General Assembly, we've talked about fictive kin or some other people who may be in a child's life who would be better than no parent or better than a stranger. In fact, here in the Phillips case, Judge Flournoy talks about the untenable position of how DFACS would have wanted to award KB to a foster family. And he said that is such a shame because there may be great foster parents out there, but this child has never met those people. This child has a great relationship with someone that the law will not allow us to place him with, which is a stepfather.
And in that spirit, I guess, would you be open to, maybe not on this bill, but in the future, the inclusion of additional individuals so that the court could have broad discretion and the statutory framework wouldn't be an obstacle to doing what's in the child's best interest?
I'm not opposed to that. If you look at what's in the list now, the list is all biological relatives plus an adoptive parent, which has a legal relationship to that child. Now we're adding a true stranger, which is a step parent, meaning not a blood relation, not someone who adopted that child. You're talking about, but clearly someone who's been around the child a lot by virtue of being married to the parent. I don't know what types of parties you're talking about, but I do know with the reality of our families today, oftentimes a child's closest relationship is with someone who's not any of these people.
Thank you.
Thank you, Representative Abstration. Representative Quick.
Thank you, Madam Chair, and Representative Baskin. Of course, you and I have had just a few conversations about this bill. I want to just make clear, though, for the committee, we blurred sort of three concepts as we've been talking through this. There is a mechanism by which third parties can obtain custody if by proving the parent unfit. That's not this statute that you're seeking to amend. That's a separate action and a fitness standard.
That's correct.
And so the fitness standard is there, and it's in a third-party context, third-party non-relative context, because the parent has a recognized constitutional liberty interest that the Supreme Court of the United States has recognized, and so has the Georgia Supreme Court, correct?
Right, and I think that same constitutional right is recognized in the cases under this statute right here. The court will not award custody to a third party without going through making findings of fact and law, looking to the best interest of the child, and with the rebuttable presumption that the parent is the parent of choice.
But in this context of the best interest standard, that's a lesser standard that to this point, the policy choice has been these enumerated list of relatives because of the parent's liberty interest in custody, correct?
I would agree with you.
And so this would be the first really policy choice, if you will, to add a non-relative and deal with the concept that I'm going to date myself as to when I went to law school that we used to talk about as the psychological parent of a child. That's could be any individual, right? That's sort of what Representative Abstration's talking about.
Right.
This is a big shift, is what I'm trying to underscore, correct?
But the change that I am advocating contemplates the reality that the award of custody happens not with a change of custody later, but when the court is awarding custody incident to divorce, and judges want the discretion to be able to make an initial award of custody to a step-parent. And unless we put that here, they will not have that discretion. I think clearly the next case is going to be a parent that happens to. It would have been this case. Had the statute read as I'm advocating now, then the case would have been about whether that had deprived Misty Crosland of her constitutional right. I think this is the right thing to do. It recognizes a reality of our families today, and that is my ask to the committee.
Thank you. Thank you, Representative Quick. Who is all the way down? Yeah, Representative.
Yeah, thank you, Madam Chair. My question is, I'm very familiar with the step-parenting piece within my family, so I always tell the story about my dad. He was one of the kind of guys that just took the word step out of father, and you begin to call him daddy. But that came over time, and it takes time to get to that point in relationships. Is there any kind of timeline or something the same relationship you have that a kid will gain in 1 year is not going to be the same as they will gain in 5 years or 10 years. Is there any timeline on the step parenting piece? Because it takes time to build that relationship.
Right. Thank you for that. That's a representative. That's a great point. And in this case, you realize that the parents had been married for, a while, 5 years. They had gotten married in 2006 and divorced in 2011. But it goes back to the judge's discretion and has to enter findings of fact and law and look to the facts of each particular case and would look into the nature of the relationship between the step parent and the child. But no judge would ever award custody to a step parent that had just been, a cursory relationship that lasted only a short period of time, that was contentious, or any of that. This is simply adding one type of person to the list a judge can award custody to.
So really, it puts the burden on the judge to make a decision whether that step parent is capable or competent to.
Yes. Yes, absolutely.
Thank you. Thank you for your bill.
Thank you, Representative. Representative Holcomb.
Thank you, Madam Chair. I understand how Mr. Phillips was either a stepfather or former stepfather because of divorce.
Right.
Would he have also been a former step parent because of death if KB's mother had passed away?
Yes, and that comes up frequently. That could absolutely happen. And so, in that kind of case, depending on the other biological parent, who would be the presumed person to have custody of that child, if the child is truly an orphan, then that would help that person have standing to bring a custody case towards that child.
Thanks.
Okay. Thank you, Representative Holcomb. Representative Oliver.
We talked about this, and I agree that it's a fairly big change in policy based on the case law. Has this been reviewed by the family law section, and do they have a position on it?
It came up in my Weltner family law end of court meeting last month, and one of the people I just emailed about it this morning when I got this committee notice was Pilar Prince, who's the chair of the family law section. Let me check. I don't think I've heard back from her yet. But I did ask Judge Flournoy if he could be here today, and understandably most judges are busy 5 hours out. So he said, sorry he couldn't be here. He'd be happy to testify here in the future, but I did save the email where he said that I was authorized to tell you all he does support this bill.
The family law section is the largest section of the bar, and it's 60% of the cases that go into the civil courts. I just think they've provided a really good service on these very hard issues, and this one is a hard issue. The most common tragedy I see in these cases, and historically, is the death. You have an intact family, second marriage, the bio parent dies, and the step parent has really been the only parent. But and there are tragic consequences of that. But I'm a little nervous about this policy change without a family law section vetting.
Well, I think everybody in the family law end of court, most are members of the family law section, and the consensus at our meeting last month in February when this came up was, why haven't we done that yet? Absolutely. Every practitioner would love to have the opportunity and a good argument to argue to the judge that it would be in the best interest of a child to be awarded to the step parent when the bio parent is terrible. Everybody in this whole case acknowledged that. The mother said, my daughter's terrible. DFAC said, we're stepping in here. The stepfather was the only adult in the whole room, and then our court system deprived KB of that dad, and the Court of Appeals asked the legislature to do something here. So we're here today at a committee meeting, and we have the ability to vote on this.
Okay, thank you. Representative Cantrell?
Madam Chair, I'm prepared to make a motion if you would be ready to hear it.
Okay, are there any other questions in the committee? Representative Cantrell, I'll recognize you for a motion.
I move do pass.
We have a motion from Representative Cantrell to do pass HB 305 LC 410980. Is there a second? Second, multiple seconds. Is there any discussion? Okay, so we have a motion and a second do pass. How does the committee vote? All those in favor signify by saying aye. Aye. Any opposed? No. Raise your hand if you're no, just so. Okay. Okay, we have 4 noes, and how many yays if you're for? Motion carries. Thank you, Representative Beskin. And that concludes our agenda today, and we are now adjourned.
Thank you very